May I pray that the item number 10 of code number 7 may be taken up on 20 of this month?
Difficult. I appear for the respondent.
Petitioner.
Sorry.
Item 10, 21. Once.
20.
May I please, your lordship? My lord,
Yes.
I seek permission, your lordship, to move urgent petition tomorrow, my lord. Motion, my lord.
Tomorrow it's not possible.
Lord, construction matter, my lord, within the Patta land, my lord, construction already started, my lord. Otherwise, my lord, the petition will become infructuous, my lord.
What is the issue? Eviction?
Compensation, etc., my lord. Road is being constructed, my lord. Bifurcating of Patta land from the middle, my lord.
Listed in.
Oblige, your lordship.
May I please, Lordship?
Yes.
I filed a writ petition. It may be listed on 19th of this month.
Why 19?
19th, the court will reopen after vacation. Obliged.
Lordship, I beg to mention for listing, my lord, maybe on possible tomorrow, my lord.
Why?
I filed on, my lord, Monday, my lord. It was not listed, my
What is the urgency?
post eviction, my lord. Ousted from the shop rooms, my lord.
You have already been ousted.
Yes, my lord. Most of.
May I please, I beg to mention item number 2, Lordship. Either maybe
Item 2.
item 2. Either maybe adjourn for the case.
Huh? Item 2 of this court.
Yes.
On the prayer, Mr.
ABT Hawk.
Huh?
ABT Hawk.
ABT Hope, learned counsel for the petitioner. List this matter after 3 weeks.
May I please, your lordship? My lord, I'm my lord, praying for listing of few motion matters tomorrow, my lord, regarding eviction, and by Sunday, my lord, we may going to be evicted, my lord. My lord, filing is going on, my lord, numbers I am providing after
No,
and
no. You have to first file it.
Yes, sir.
Lord, filing is going. Oblige, my lord.
May it please your lordship, with the consent of the other party, I beg to mention item number 11, lordship. Lordship, the matter may be taken up after Bihu, lordship.
11. What is there? Huh?
Lordship, the lordship,
2015 matter.
my senior is suffering from viral, lordship.
Who?
Lordship P. Mohanta, lordship.
Huh?
Lordship P. Mohanta.
P. Mohanto. MS so-and-so learned counsel appearing on, your name is there?
Lordship,
Appearing on behalf of Mr. P. Mohanto, learned counsel for the petitioner, submits that Mr. Mohanto, learned counsel, is suffering from a certain illness. Therefore, is not in a position to argue this matter.
May I please?
About 5.
And as such, fresh for adjournment of the matter. To 3 week adjournment, please. Although the matter is of the year 2000, and the matter is pending since 2015. In view of the illness of Mr. Mahanta, the prayer for adjournment is allowed as a last such. According list this matter after 2 weeks.
My lord, item number 5, my lord. Did not get it. My lord, my learned friend is there, my lord. Can it be fixed after Bihu, my lord? I'll get it.
On the prayer, Mr. J. Payang, done it.
Council for energy.
Standing Council, NRC. List this matter after a week. After 2 weeks, Mr. SD, Learned Council petitioner is present.
May it please your lordship. I'm praying for urgent listing tomorrow. It is an eviction matter. I have already filed. Yes.
Motion. It's a motion matter.
Yes. supplementary court date, authorized 14.
If the matter may be passed over for the time being, Mr. D Nath is appearing in this matter. He is
Who?
of death in court number 1, D Nath, Dipankar.
Will issue notice what's there?
No, no, my lord, I have to say that there's an order for, my lord, interim orders also, my lord.
Interim order will consider next, already sealed and investigation
No,
is
no.
over.
No, my lord, investigation is over. What is this, my lord? So I am suffering. I
Will
being
issue
the-
notice,
I being-
what's
no, no,
there?
I am being, no, I being the partners. I being the partners. Now, the entire.
That is
factory-
your ill luck.
No, not ill luck is what, under what, when a provision of law, this has been sealed, my lord. There's no provision at all. And my lord, if your lordship kindly see the affidavit which has been filed, instead of this thing, my lord, I am ready to pay the amount which they are saying that section 107 BNSS, they have filed this application, my lord, for attachment of the property, my lord.
Hmm.
Now, entire factory is of, under the lien, under the State Bank of India.
Hmm.
The State Bank of India is, I have to pay about 25 lakhs. Well, and 2 lakhs 50,000 per month.
What sort of interim order you want?
My lord, this order has to be stayed because unless I can operate. See,
No,
my
no,
lord,
once it is stayed, matter ends there.
no,
We'll-
no,
we'll-
my lord, there-
Sir,
no,
we'll
no,
consider,
there-
we'll consider only, we'll issue notice today.
my lord, no, because the respondent has filed their affidavit. my lord.
Hmm. Where? In this matter?
Yes, my lord, they have
Ah.
filed their affidavit, my lord, because of what, my lord, urgency, this matter has been kept in a motion, my lord.
Hmm.
They filed, what they said, that they have filed an application under 107 for attachment of the property, that property.
Hmm.
Now that is a separate asset. Now if I can run, my lord, I am ready to pay the amount to them. Instead of that, my lord. if
After
I-
some time. After some time.
Okay.
Yes.
I did one.
Lordship, in this case, we have filed our affidavit.
Hmm?
Our affidavit, Lordship, I am appearing for response number 5, 4, 5, and 6.
So pleadings are complete. Now it appears for the petitioner on call, MS Ardeka.
I am appearing for respondent number 7 and 8. P board way.
For
7 and 8.
7 8 is who? Who is the 7 and 8?
Private respondent.
Private respondent.
You have also filed affidavit. Learned counsel for respondent number 4, 5, and 6, and 7 and 8. And who else, sir? 1, 2, 3.
1, 2, 3.
All of them have filed the affidavit.
1, 2, 3, 4. 1, 2, 3, do it 3 days over.
All the respondents have filed their affidavit.
1, 2, and 3 have not filed their affidavit.
And then so and so submits that affidavit have been filed on their behalf, on behalf of the appearing respondents.
Mr. Vimal.
1 and 2, who is 1 and 2?
Right, so, this one.
You have not filed affidavit. Have you filed the affidavit? Very strange. Huh? List after 4 weeks.
Plus,
And then 3 and 4.
Yes.
I am for the bank, my lord. in this
Ah.
case. Assam Tea Corporation is also appearing last time I think AG has appeared in this case. I think there is some difficulty in this matter for them, I think. ATPL, Assam Tea Corporation Limited, they have some difficulty. I think it has been, they have called in. So my lord will take up any other date which is occurred.
And Mr. D. Das, Learned Senior Counsel, assisted by Mr. A. Ganguly, Learned Counsel for the petitioners. Two petitioners.
I'm on 80 PFO.
So you are seeking time.
Assam Tea Provident, sir. Their provident. ATCL.
Who is taking time?
My lord.
Who is seeking for adjournment?
He's here.
Any day, my lord, after vacation, if not in.
What vacation? Vacation is over. As spread for land council, no, on the prayer of Mr.
Respondent number 2, my lord, Assam Tea Corporation.
Standing I mean, additional advocate general. Correspondent, list this matter after, and as agreed to by the senior counsel, list this matter after, or sorry, 2 weeks. Huh.
Lordship, my senior is in leg. Kindly pass over for time being.
And the pleadings is otherwise complete in this
Ah.
matter.
What is the matter?
Matter is with regard to the rights of the occupancy tenants.
Huh.
And there was a determination by the revenue authority regarding
Against you, determination against you.
initially it was in my favor, then
Ah.
they filed a petition. On their petition, my lord, it was reversed,
Review.
reviewed, and after review, my name and my what is called the royalty rights have been deleted from the Patiyan. Now, after the before
In your place, anybody has been,
no, actually, this thing is like this.
only your name has been deleted.
My name, not only my name as well as the name of the land original Pattadar.
Okay.
I am a Rayati
Ah.
settlement holder under
Now,
the
who are these people? Who are else, sir? 6, 7, 8, 9.
6, huh?
6, 7, 8, 9.
6, first is item number 8, huh?
6, 6.
First 8 may be,
Huh?
item number 8 may be taken first.
These are,
Item number 8, my lord, in item number
no,
8.
no, these 7 and 8, 9 there, all their names have been deleted.
Oh, your lordship is referring to the respondent number.
Not yet deleted in terms of the interim order.
In
Huh?
terms of the interim order, my lord,
They
the
have not deleted.
দাঁড়াও না, মাঝখানে কথা বলতে পারো না।
Ah.
The interim order, because of the interim order passed by your lordships, my lord, the order of the revenue board has not been acted upon.
Ah.
But the effect of the order is that. if
No,
that-
I'm asking why these, the 4 persons,
No,
4 petitions
Now,
in respect of same land.
same land. No, আরে দাঁড়া। না, তুমি করো তাহলে আমি যাই।
Ah.
Now, here your lordship will kindly see the settlement. I am the.
You, Mr. Hussain, Mandal, you are Mandal, Hussain, you have not
My lord,
brief, you have not had a conference or brief with the senior lawyer last night? Where you were? Now I just wanted to know,
Now, this.
what are these other, where on item number 8,
Yes. Now, this
all these
private.
petitioners,
Your response, lordship.
no,
is
no,
referring
all
to-
these petitioners 6, 7, 8, 9. Okay. Are they in respect of the same land or different land?
No, the writ petitions are in respect of different land.
Different land,
Different land.
but then the order is,
Or order is, by one order, my lord, everything has been taken into fold.
okay,
That is one limb of the grievance.
okay, so there is separate
Separate pattas.
petition, but then order is, impugn order is same.
Or by impugned order, my lord, actually, what the revenue board has done, although there was no challenge limited to the rights of the parties, they expanded the ambit of the order and included all.
All these
and-
petitioners?
Yes.
Okay. So what is to be done?
But if he is having difficulty, my lord, some other day,
My
your
senior is in.
Who is your senior?
Mr. J. Roy.
J. Roy. Their last occasion, they expressed some urgency.
yes.
Yes, only you have to defend what is your stand. J. Roy is a private respondent. Huh? No, but your action has been put to challenge. Then we'll hear him later. First, we'll hear you. Huh? Are you ready? That's why I'm asking. Vacation is over now.
No, they are referring to the view vacation, my lord, next week.
And we're restrained from not, restrained from using the word vacation.
Well, suitably it can be termed as holidays.
Not holiday, even not holidays. Partial working days. For lawyers, it's a holiday, vacation. For judges, it's a, I mean, 24/7.
From February, the first Saturday and the third Saturday is also working day.
Throughout the year, where I think judges are on the job. We miss the privilege, personally. Anyway, when?
Any republic or
Immediately.
As agreed to by Learned Senior Counsel, Mr. S. Datta, assisted by so-and-so, and Mr. J. Roy, Learned Senior Counsel, assisted by so-and-so, and Mr. N. Das, Learned State Counsel. Let this matter be listed after 3 weeks. 3 weeks.
Let the date be fixed, my
2
lord.
weeks, give the date.
27th, my lord,
না না আমি 27 পর্যন্ত নাই
or
ফেব্রুয়ারি 5 তারিখে রাখো
no,
হ্যাঁ থার্ড হ্যাঁ থার্ড ফেব্রুয়ারি
before the 21? 21 February?
21 February হ্যাঁ ঠিক আছে
Yeah.
21 February will be Saturday.
No. Oh, January, 21 January.
21 January Wednesday তো
Or 22nd January, my lord.
22nd January. I think it's not possible.
22nd January February বলছে
We fixed so many matters.
3rd February.
Hmm.
Well, there is an interim order that may be continuing.
In all the cases, interim order passed earlier and continues.
Publish.
Your Honor, may I request for a short passover? My senior is on legs in another court.
We're passing
Miss-
over all the matters. What is there? What is this IA?
Your Honor, we have filed the IA.
For what?
Your Honor, my senior will apprise this court. My senior is on a short passover, my lord. Short pass. She's on legs on the court.
You have been restricted to,
My lord, so far as the contempt is concerned, because the demarcation was directed to be carried out in respect of plot of land. That was not, my lord, carried out in the manner that is required. Therefore, the contempt was filed and the notice was issued. And IA is, my lord, to stay the contempt proceeding.
No, demarcation.
to stay the
Stay the
contempt.
demarcation. Stay the demarcation.
What does it mean?
And my lord, so far as the main contempt case is concerned, the government advocate was granted time to file affidavit.
Hmm.
3 times, my lord, affidavit
Hmm.
has not been filed. yet.
But she's saying,
Contempt.
Short passover.
We have not
Short.
stayed.
No, no.
Yeah, no? My
They
dear-
have filed the additional.
my dear-
Why do this to?
Let it come some other day, let him furnish a
Your
copy.
lordship, we have filed most probably some, but I have. No, okay,
sir, why this IA?
IA lordship, the IA.
IA is for what?
I is for the stay of the demarcation proceeding. That was directed. earlier
Directed by this court. What does,
That is in the read petition, my lord.
that's why I wonder.
Against that, my lord, read appeal was
If
filed,
he's-
that was also.
He can, she may file vacation of that order or modification or file an appeal.
Yes.
But in this contempt proceeding, how can this be, I mean, maintainable?
Lordship, any day lordship, as because they copy, they have not received.
The, which one?
In the copy.
affidavit which is filed by the first, respondent number 1.
In contempt?
We have
Okay.
received the copy, he'll furnish a copy, my lord, let it come some other day.
I think other day we have taken up this matter. I vaguely
Yes, my
remember.
On that day also, my lord, adjournment was granted.
I'm scared of,
Actually,
I'm scared of hearing MS Burwa. if my memory serves me correctly, that they also have indicated why are you here? So we'll adjourn it. Heard Mr. M.K. Chaudhary, learned senior counsel for the, assisted by M.S. Arbora, learned counsel for the petitioner. Mr. H. Sharma, learned counsel
Respond number
for
one.
Alice container number 1. Submits that although he has filed the affidavit as directed in the matter, no copy appears to have been inadvertently served to the learned counsel for the petitioner. Mr. In view above, and as agreed to by learned counsel, let this matter be listed after 2 weeks.
Sorry.
Yes,
Lordship,
yes.
I'm appearing for petitioner here.
Ha.
This is, writ petition has been filed, Lordship, against the notice for eviction here. That is page 22, Lordship.
Ha. Affidavit has been filed.
No, Your Honor, till now, Your Honor, state has not filed any.
Who is for the state? Who is the main respondents?
Your Honor, notice was received by respondent number 4.
Whatever. The commissioner, deputy commissioner.
Yes, actually, Your Honor, I have filed a petition before the other respondent authority for settlement of that plot of land. On that's why they made also parties here.
No, it's okay. But what is there? What is your case?
Lordship,
Are you ready, Mr. Sharma?
Lordship,
No affidavit has been filed.
extremely
It's
sorry,
an
Lordship,
against
our file is misplaced in the office, Lordship, that is very difficult,
Very difficult.
Lordship.
Lordship, kindly peruse order dated 27/11/24.
27/11.
24.
So for instance, from district admin as well as revenue, however, there is no instruction placed before this court. Unless this court admits the instant petition fixes the matter for hearing its interim order process until the display. Yes.
They are, Your Honor, delaying the matter, Your Honor.
No, it's okay. What is your ground?
Lordship, my ground at page.
Why you should not be evicted?
Lordship, I have already filed a petition for settlement of that plot of land.
Is it a ground not you to evict? Because as on today, there has not been settled in your favor.
Yes, Your Honor.
Until that time it is settled, you are an encroacher.
Lordship, my
Or you are the illegal occupants. So what's wrong?
Lordship, my petition is pending for consideration before the.
It's okay.
Deputy Commissioner.
Pendency will not bar to evict you because admittedly you are an encroacher or illegal occupants, unauthorized occupants.
Lordship,
Until that time it is settled.
Lordship, exactly. That's why, Your Honor, till my
So
death
we'll-
should be considered.
We'll dismiss the writ petition. However, we'll direct them to consider your case. That's all.
Lordship,
Nothing else.
prior to eviction, Lordship, that may
Huh?
be considered.
Huh?
Prior to
No,
take
no.
any action upon that.
You
notice,
tell us
Lordship.
why you should not be evicted. Except for your application for settlement is pending. That is out. Mere pendency of for your prayer for settlement will not be a
Lordship,
bar to
Lordship,
issue.
I'm possessing that plot of land
It's
for last
okay.
2 decades.
Doesn't matter.
Yes.
Maybe 3 decades, 4 decades, 5 decades.
Lordship, my petition will be considered.
Huh?
That petition for settlement, that may be considered by the respondent authority.
But then we're dismissing the writ petition.
You know, at any moment we will be evicted if
Obviously, because there's no reason to interfere. Because you are not able to establish that no eviction, the order could have been passed, except to say that your matter is, your prayer for settlement is pending.
Yes.
Until the time it is settled, you can be evicted because you are not legally, your occupation is not valid. Right? So,
Lordship, kindly my ground number E. In my petition, page 7.
see, as such, we're not inclined to interfere, but then since they are occupying it for the last 2 decades, you just consider.
By council, Lordship.
Will not say anything on the impugn order. All right.
Lordship, kindly my ground number E in my petition.
Where is their ground? Ground number E,
Yes, Lordship.
where it is?
Page number 7, Lordship.
For the proposed action of which is going to be undertaken by respondent is also against the present land policy state of Assam, where is the respondent has applied in a name for respondent and one another member of her community and the other and the other member of the community belongs to settled tribe. Contains one dispute for settled caste and settled tribe and as per Act clause 6 stated for given to me. No, these are to be considered by the
Let go.
state only.
Yes.
Anyway, heard, mister?
As they.
This is what, these are as they
As they.
learned counsel for the petitioner. And Mr. H. Sharma, learned state counsel for all the respondents. Who is 1 and 2? Revenue. Yes, madam. Revenue. You. Then and also heard Mr. M. A. Bhattacharya, learned state, the standing council, revenue department, correspondent 1 and 2, and Mr.
3 and 4.
S. Sharma, learned state council for respondent number 3 and 4. Challenge made in this writ petition is to the notice for eviction dated 28/07/2020 issued by the circle officer Dispur Revenue Circle, Dispur, huh? Whereby the petitioners, how many? 1 or 2?
Lordship,
You are 2 petitioners. This is one petitioner only. 1 person only.
Lordship, actually notice was issued in the name of respondent number 2.
Petition number 2.
But I am possessing the land, Lordship.
You are there. No, this is issued to Dhaniram Bodo.
Bodo.
Dhaniram Bodo.
Notice issued to Lordship,
Petitioner number 1.
petitioner number 1, but I am possessing land.
Whereby the petitioner number 1 has been directed to vacate the land, Sarkari land being Sarkari Dag number 524 of village Betkuchi under Moja Beltola. Failing which eviction shall be carried out. In accordance with the, as per the rules of Assam Land Revenue Regulation. List of. The petitioners claims that they are in possession of the land measuring land of what? Land
Lordship, page 12.
land
schedule is there.
Measuring one cutter pipe lecture covered by Sarkari Dag number 299 within bracket all the bracket close oblique 524 within bracket new oblique bracket close of revenue village Betkuchi under Moja Beltola within the jurisdiction of Dispur Revenue Circle, Kamrup Metro, Guwahati. Since the month of October 2000, this stuff, the petitioner petitioners being the businessmen, a business by business being a business by profession are running a shops on the in the said land list of next para. It is the contention of the land council, it's the contention of the petitioners that since the petitioners are in possession, are in the possession and occupation of the occupation and possession of the occupation and possession of the land in question since last 2 decades. They have applied for holding number before the office of the Guwahati Municipal Corporation as well as the Deputy Commissioner Guwahati Municipal Corporation Guwahati for issuance of holding certificate to the petition number 2 on 20/01/2020 and 06/11 and no, sorry. It's just applied for holding number of the said land in question. List of the list of pursuant thereto the office of the Guwahati Municipal Corporation has issued a holding certificate to petition number 1. Petition number 2. The by dated 20/01/2020 and 06. No, 20 being holding number being certificate number GAS/L2/10/19-20 para 5 and 06/11/1230/754 under ward number 6. The petition number 2 is regularly paying the required municipal tax to the Guwahati Municipal Corporation. It is further contended that the petitioner number 2 and her adjacent landholders also applied for settlement of their respective lands on 30/12/2019 before the appropriate authority. List of next para. Mr. So-and-so, learned counsel for the petitioner submits that the respondent authority, particularly the circle officer, dispute revenue circle, so that before consideration of the settlement of the said land in favor of the petition number 2 has illegally issued the impute notice of eviction, notice for eviction. This stuff. The concerned officials having been visited the area and made inquiry, the petitioner were under the impression that the case of the petitioner for settlement of the land in question shall be considered. However, without following the due process and in violation of the provisions of what provision? Provisions of the land policy 2019, as well as and the land regulation of the state of Assam, the eviction, the impugn eviction order has been issued. Therefore, he submits that the petitioner, the respondent authorities may be directed to consider the case of the petition number 2 for settlement of the land in question in favor of the petitioner number 2. Next para. Mr. So-and-so, then counsel for the respondents fairly submits that since the application, since the prayer for settlement of the land in question is pending before the appropriate authority, it would be appropriate if this court directs the concerned authorities to consider and dispose of the application of the petition number 2. Next para. In accordance with law. Next para. Upon consideration of the materials, it transpires that the petitioners are occupying the land, although occupying the land in question, although for 2 decades, without any valid documents, as on their own showing, the application for settlement under the relevant land policy of the state is yet to be considered. Please stop. Until the time, until and unless the settlement is made in favor of the petitioner number 2, the petitioners would not have any right to claim over the land, would not have any right to claim over the land in question. At the same time, it would be incumbent upon the respondent authorities to consider the grievance of the petitioners, petition number 2. Grievance of the petitioners for settlement in accordance with the land policy in vogue in the state of Assam, in the state list of. Next, in view of the above, I deem it appropriate to dispose of this writ petitions with a reduction to the respondent authorities to consider the consider and dispose of the, what is that application? Application for settlement of the land measuring so and so, that same so and so at Moja, so and so, so and so. Within a period of,
6 also.
huh?
Lordship. Page 21 as well as page 26.
Anyway, applications, huh?
That was a rectification, Your Honor, regarding the DAG number as page 26.
No, I have not mentioned that recorded. Settlement so and so, so and so, huh? Pandag number so, within a period of 3 months from today, in strictly in accordance with the law.
Right.
Petition is
The
stated.
petitioner shall submit a copy of this order along with an application afresh, Lordship, and because it's a case of 2020, it will be convenient for them, Lordship.
Then the petitioner as submitted by the learned state council, let the petitioner to the petitioner to file submit fresh form of application for settlement of the said land so and so, so and so within a period of 10 days from today. 10 days from today.
Lordship, PU vacation is there, kindly. that-
Where we're concerned, it's a matter of 1 day only. And within a period of 20 days from today, huh?
Thereafter, within 3 months, they will consider.
Then we'll make it, then you say, then don't say that, earlier, 3 months, huh? Then thereafter, the respondents shall consider so and so within a period of 3 months, huh? Not thereafter, you said the respondent authorities shall consider the case of the petitioner so and so within a period of 3 months thereafter. Huh? What to do over the eviction? It was to be within 30 days. Till it is till the consideration of the case of the petitioner, the impugn order so and so, so and so shall not be given effective.
Highly obliged.
Huh? 14? Yes,
314.
we have enough time today.
My lord, in this case, my lord, dear lordship, they have filed their affidavit, my lord.
Yes.
My lord, may I pray, because there are two separate, one is regarding legality and validity of the order which has been passed under challenge.
Notice has been issued or what?
No,
Yes.
No, Lordship.
not notice has been issued. Now, there are two things, my lord. While coming, while fixing the matter yesterday, my lord, they have filed an affidavit saying that they have filed an application before the court of the trial court regarding, my lord, attachment
Attachment.
of property.
Hmm.
Now, what my submission is, these two are different things. 107 of the, my lord, BNSS. Now, there a notice has been issued. I received the notice. I have to, my lord, go and I have to give a reply to that. That is one aspect. Another aspect regarding, and in their affidavit, what it says that the purpose of attachment is to recover the 1.1 crore which the person, the accused has invested in my factory. Now, the thing is just there, the whole object is to realize the 1.1 and to give to the victims. So, my lord, I can undertake, my lord, I can give you the 1 why I should be suffer, because entire my machineries, all these plans has been lent to the State Bank of India, and State Bank do not hear that this matter is sub judice, that's so and so. I cannot this remove excuse for giving the EMI. Bank will not hear all this. Bank knows only the EMI has to be paid, otherwise it will be NPA, then there is another subject. Now, the entire property is lent to the SBI. The SBI also not made a party to that proceeding. That is one aspect I am not there. If I may not undertake that 1.1 crores, they want this thing only to the government. They will give to the victims. Now, that is one aspect. Second aspect is this, in the 107 applications, my lord, how can I say that is a proceed of crime unless and until the trial and when evidence comes? It's a matter of the prima facie they found that these are the money which has been, my lord, taken from the deceased. The prima facie found. Now, whether it will be, has been taken or misappropriate from the deceased account or not, that has to be ascertained by the court of law, my lord. That is a trial court only, my lord. Am I right, my lord? So, unless and until,
You may be right or you may not, you may,
my lord, so far I am concerned, my lord, I am a victim. Similarly, my lord, and how can I know this person? Suppose, my lord, they come with me, set up an industry of drinking waters, my lord, investing money, and I have invested to the tune of 5.5 crores, my lord, by taking a loan, my lord. Lordship has to see that where I will go, my lord. I undertake that, yes, if I open, my lord, I will give the money to them, 1.1, and it is their affidavit only. So
what
that
do
is-
what do you want?
My lord,
I'm not getting what you want to say.
not what the government of,
You have filed this petition against the order of
yes, my lord,
Sealing.
Sealing, my lord.
that has already been done.
That has been done, my lord.
Done.
Then,
Now,
now,
so for attachment,
that's the difference, the
no,
difference.
the attachment, they filed an appropriate, application before the appropriate court.
Court, yes, my lord.
That is pending.
That is pending, and I have been given a show cause notice to that, giving a time to 17th of January. my lord. That is another aspect. I am on the order which has been issued, the legality and validity of this order. I am stick to that only. That there's two separate entities. Now, in their affidavit, they said, they didn't say about that what is the illegality of those orders or legality, whether it is legal or not. They have not said, my lord. But what they have said, my lord,
So we'll give them a chance to say them on this petition. We have not issued a notice. Notice has been issued or what?
Lordship may kindly.
See, matter is very simple.
Lordship.
What he's trying to ask is that the sealing procedure, sealing of the factory is not in accordance with law. Number one, by keeping it sealed, they are suffering a loss, as they have borrowed the money, taken a loan for the establishment of the factory. They have to pay the EMI. Therefore, the sealing has to be stayed or set aside.
Two submissions.
Yes.
Number one, they have approached this honorable court saying that they have no alternative remedy, nothing is there because their premises is sealed. They have no option, therefore writ petition to deseal the premises. We have come up with the instructions that the proceed of crime has been invested in that particular business. As per under section 107, we have taken steps. Under 107, my lord, already court has issued notice. Notice has been given to the accused person as well as to the petitioner. So he has the remedy. He can go there. He can very well inform the court that these are the investment. These are the things. He has only this much of investment. I have the other 5 crore investment. Everything can be decided there. If lordship for a moment, second submission is 107 is a detailed procedure prescribed. If lordship kindly takes up 107 of the BNSS for a moment,
BNSS.
kindly see trial is evidence is not required. Kindly see, my lord, 107 of BNSS. And the order of the trial court that I have next, I'll take your lordship to that. First, kindly see, 107
Section 107.
Restoration of property, where a police officer making an investigation has.
Just wait.
Lordship. 07.
No, I have this. 107. Yes, attachment, forfeiture or restoration of property. Yeah.
Restoration of property, where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of the offense, he may, with the approval of the Superintendent of Police or Commissioner of Police, make an application to the court or the magistrate exercises jurisdiction to take cognizance of the offense or commit for trial or try the case for attachment of such property. The court or the magistrate has reason to believe, whether before or after taking evidence, that all or any of such properties are proceeds of crime, the court or the magistrate may issue a notice upon such person, calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. This notice has been issued. Where the notice issued to any person under subsection 2 specifies any property as being held by any other person on behalf of such person, a copy of notice shall be served upon such person. So the petitioner is the other person in this case, because he is not the accused. Then the court or the magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material facts available before such court or magistrate, and after giving a reasonable opportunity of being heard to such person or persons, may pass an order of attachment in respect of those properties which are found to be proceeds of crime. So petitioner has all the opportunity to place it before the trial court that these are my investment, these are his investment. So his investment ultimately that court can consider, provided that if such person does not appear before the court, then court may go ex parte. Notwithstanding anything contained, notwithstanding anything contained in subsection 2, if the court or the magistrate is of the opinion that issuance of notice under the subsection would defeat the object of attachment or seizure, the court or magistrate may, by an interim order, pass ex parte direct attachment or seizure of such property, and such order shall remain in force till the order under subsection 6 is passed. So under subsection says.
Yes, I have read.
So there is a detailed provisions procedure prescribed under 107.
That's why he said this is another aspect. That is for attachment is pending. You have filed an application for attachment. Now it's pending. What he's aggrieved is that you could not have sealed the factory without authority of law.
Kindly
So
come
that
to
you have to explain in this petition.
para 10 of my affidavit.
Ah.
Para 10, Malad.
Affidavit. Just wait. Where is that affidavit? Huh?
My affidavit starts at page 66.
66? There's no affidavit. Where is the affidavit?
Text yesterday, Malad. We filed on 6/1.
It ends at page 65, petition. Oh, the problem. Okay. Respond number 3.
Page 68. Statement made in para 6 of the writ petition, the deponent begs to state that the district administration have the prerogative to seal the premises in the interest of the ongoing investigation, that is CIDPS case number 18 of 2025. Section 106 of the BNSS provides that any police officer may seize any property which may be alleged or suspect to have been stolen, which may be found under circumstances which create suspicion of the commission of any offense. By a speaking order, the district administration had made the seizure procedure complete. The what he has said that on the pretext that we deny, my lord. Then kindly come to para 10. In that page only, 69. The deponent begs to state that the petitioner's partner Siddharth Sharma had himself laundered money through several persons, some of them are mentioned below. During investigation, this reveals, my lord, by paying his employee Dharmendra Bashya, an employee of Mahabir Equa, in cash and directing him to transfer the exact amount to his Siddharth Sharma's bank account so as to legalize the cash deposits. In another instance, Siddharth Sharma paid Sri Rishabh Fagar rupees 40 lakhs in cash and got it transferred to his bank account. Thereafter, those amounts were shown to be invested in the Mahabir Equa firm. Sri Konkon Talukdar of MS MK Enterprise had deposited rupees 7 lakhs into the account of Deepak Sharma, brother of Siddharth Sharma, which was again transferred into the account of Siddharth Sharma. He had admitted under section 183 BNSS that he had taken rupees 20 lakhs in cash from Siddharth Sharma and transferred the amount to Siddharth Sharma's bank account, and rupees 7 lakhs received in cash transferred the amount in the bank account of Deepak Sharma as directed by Siddharth Sharma. The petitioner's partner Siddharth Sharma had borne the same modus operandi to launder his ill-gotten money siphoned from his employer late Jubin Garg. These Benami transactions and money laundering laundered by the partner of the petitioner is the crux of the issue for which the seizure of the Mahabir Equa was extremely necessary. It is stated that an application has been moved before the court of the Ladet Session Judge Kamrup Metro, praying for invoking section 107 of BNSS for attachment and forfeiture of property acquired by one of the accused in CID PS case number 18 of 25, Siddharth Sharma, and the same has been registered and numbered as Miss case number 1 of 2026. It is to be mentioned that the petitioner number 2, Sri Chetan Dhiracharya, he is the petitioner here, is the business partner of Siddharth Sharma, and both had invested in the petitioner number 1 firm, Mahabir Equa. It is stated that the Ladet Session Judge Kamrup, by order dated 3/1/26 passed in at the aforesaid Miss case number 1 of 2026, issued notice upon the Siddharth Sharma and Chetan Dhiracharya, partners of the petitioner number 1 firm, and fixed the matter on 17/1/2026 for show cause reply. So, my respectful submission is the petitioner has all the remedy available before the trial court. The petition, the proceeding is pending there. If the trial court, after considering his show cause reply, finds that the entire this much is the amount invested by Siddharth Sharma, and this is the investment by the petitioner, then the trial court has every power to pass the appropriate order there. Otherwise, the manner in which this has been challenged, that you deseal the property, the entire investigation and entire thing will be frustrated.
You filed you have already filed the charge sheet?
It is filed. Property, if property is not kept on the seal, they will liquidate the property. Who will guarantee, my lord?
How can it liquidate it, my lord? It's under PN of the bank, my lord.
It is, my lord. That is what to ensure. That is why the trial court is in session of the matter, my lord. 107 is there.
It has been sealed already.
Already sealed. During investigation, it is sealed. And
Right.
now 107 is there, my lord, and
For
I think-
replacement.
attachment. For attachment of the property, so the petitioner as well as the accused Siddharth Sharma, both of them were given notice. Kindly see the order of the trial court. That is at page number, it starts at page number 75, my lord. In the affidavit, Annexure 1. Parallelly, this writ petition, 75 is the order.
Okay.
So, seen the prayer made by so-and-so, Chief Investigating Officer of CID so-and-so, praying for invoking section 107 BNSS for attachment and forfeiture of property acquired by prime accused Siddharth Sharma from the process of criminal activity in reference to CID PS case number so-and-so under section
Mahabir Equa.
Mahabir Equa.
Yes, not in transfer to his bank account. After these amounts were shown to be.
It is reflected. And finally, if lordship comes to it will proceed of crime. The petition submitted by IO is registered as miscase. I have considered the prayer made by the Chief Investigating Officer, SIT CID PS.
Where it is, page 80.
Page 80, para 4. Court has said that I have considered the prayer made by the Chief Investigating Officer, SIT CID PS case number 18 of 25. I have also carefully considered the provisions enumerated in section 107 of BNSS. I have also heard the learned so and so. Perusal of the petition submitted by Chief Investigating Officer does not reflect the actual amount of share of accused Siddharth Sharma had in his business of Mahabir Equa. As per petition of Chief Investigating Officer, the accused invested 1.10 crore in Mahabir Equa, which has opened in partnership with one Chetan Dhirasaria. The petition of Chief Investigating Officer has also does not disclose the amount of share of Chetan Dhirasaria. So those are to be informed by the petitioner there. Under section 1072 of BNSS provides that if the court has reason to believe whether before or after taking evidence that all or any of such properties are proceeds of crime, the court may issue notice upon such person, calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. Section 1075 of BNSS gives power to the court to pass ex parte order in interim. If the court is of the opinion that issuance of notice would defeat the object of attachment of seizure, in the instant case, the petition filed by the Chief Investigating Officer does not clearly disclose the amount of share each of the partner of Mahabir Equa is having. As such, if an ex parte order is passed without knowing the actual share of the partners, it may cause prejudice to the petitioner. Accordingly, issue notice to the accused Siddharth Sharma and Chetan Dhiracharya, partner of Mahabir Equa, to show cause as to why the properties of Mahabir Equa shall not be attached. The show cause reply shall reach the honorable
Okay.
court.
I think,
So my
Mr. Bora,
submission-
you better to pursue there. It
No.
is only, it has already been sealed.
My lord,
Investigation is over. Now it's a stage of attachment.
my lord,
Whether it can be attached or not, you pursue there.
no, my lord, I kindly give me on 1 minute, my lord. Lordship, kindly see page 48, my lord, of my petition.
Ah,
Kindly see by 48, page 48. My lord, I want to say that two differences. Now, kindly see the order dated at what, my lord, it is a 13 October 2025, my lord.
it's okay.
My lord, kindly see,
Hmm,
last para, my lord, last para,
hmm,
kindly see.
hmm.
See, sealing is a different, attachment is a different, my lord.
Ah,
My lord, kindly see, therefore.
that's what I'm saying. It
No,
is
no,
already.
Therefore, in view of the seriousness of the case, until the matter is produced before the competent court or judicial magistrate, my lords,
Hmm.
the premises of so and so at so and so under Boko Police Station is hereby directed to temporarily, my lord.
Hmm.
Kindly see the word what has been said, temporarily, my lord.
Hmm.
The word has been said. So whether in this order, anything about 107 has been reflected, how they has come, my lord. Now, Latif, kindly see that
No, no, it's-
arbitrariness,
Yeah.
I'll show the arbitrariness, my lords.
There's no question of 107 here.
My lord,
Ah.
that's why I'm.
So
telling
if you,
this.
if you rely on this, it's over now.
No.
The
kindly-
sealing of this
then
factory is
why
over
they
now.
have not desealed this, sir? Why they have not desealed if it is a temporary?
Where is the procedure of
No,
desealing
no,
it?
my lord, there's no procedure for sealing also, my lord.
Huh?
Where is the procedure?
Why, why,
There's no procedure for sealing also.
why?
No, under what provision, my lord?
It can be sealed.
Under which provision, my lord?
Then what provision it should be desealed?
My lord, when there is an absolutely illegally orders, my lord, now you cannot do on our whims, and my lord. Now, when
It's
there,
not a whims, sir.
my lord, your lordship will appreciate one thing. October.
See,
month-
this, when you read this, in view of the seriousness, until the matter is produced before the competent court or judicial magistrate, the premise of so and so is it a directive temporary seal for the sake of ongoing, it's over now.
Now over. Now it's.
What is the question of now if
Now,
it's
now,
a,
whether the trial court has the power to deseal, my lord?
Huh?
No, the trial court has the power to deseal. Whether this order can be reviewed or any order set aside by the trial court, no, they do not have a power, my lord. Now, what they are playing, my lord, as soon as I, my lord, prefer this petition. See, if they sincerely wants to, my lord, do an attachment and recover the money, my lord, then what will you do, my lord? They will file it in the month of October or November, my lord. October and November, or even in a December. I filed the writ petition in the month of December, and now they have wake up and filed this application and third, my lord, in January, my lord. If they, my lord, have sincerely, my lord, do this thing.
no,
they will
in
definitely-
that case, if you say that they don't have an authority to seal the factory, when it was sealed in October 10, why you have not come here?
No,
Why did you
because of the-
approach?
No, because of the last sentence, my lord.
Huh?
Because of the last censor,
Huh.
the sentence, because
Huh.
I cooperated with the investigation, my
So
lord.
matter and stand.
I
So
cooperated.
now it is before the court.
No, not before. Yeah, no, because it's the searches, during the period of
That's why I'm
investigation.
saying, once it doesn't have any validity now.
My lord, then, my lord, I'll file an affidavit, my lord, lordship may fix it on 22nd, my lord, I'll file an affidavit to that, my lord. I'll file an affidavit,
Reply.
my lord. I'll file an affidavit.
I don't think so. See, at this stage, when we suppose,
My lord.
suppose if we interfere, if we pass any order, right?
I am only for the purpose of desealing, my lord. And the attachment, the part will be divided. My lord, what is
Okay.
there? Now, kindly see their affidavit, what they said, my lord, what they say. Now, what they said is, kindly see that 16, para 16. 1 point, that is not disputed, 1.1 crore has been invested. In the affidavit also, they said that 1.1 crore. I have also said 1.1 crore. Now, paragraph 16, what they said, my lord. That with regard to the entire property of the 5.5 crores, my lord, it was lent to the bank, State Bank of India, my lord. I have to pay
But the
EMI.
accused has invested 1.5,
No.
admittedly. And there's a material that an amount of rupees 40 lakhs has been transferred
No, that is.
in the name of your in your
Yes,
name.
because transferred is a partnership, my lord.
Yes.
It's a partnership.
Therefore, admittedly, he has invested.
Invested.
And
That
why not on
No,
that?
that is not disputed. That is not disputed. He has not invested, my lord.
Okay.
That is not disputed, my lord. Can they say,
Huh.
if I undertake, my lord, 1.1 crore is his money, my lord.
Hmm.
Now he's an accused. He's an accused, my lord. Now, I am not an accused of this case.
Huh.
Now, I have also invested this money. And the plant and machinery is also lent to the state
That's
bank.
why I initially said it's your sheer ill luck.
No.
You had to have a
Which are the ill luck?
partnership with one accused.
The question of ill luck doesn't arise. Why?
You're ill luck.
Definitely.
You are not an accused.
No, I am not an accused. That is
Therefore,
different.
you had a partnership who happens to be an accused.
What my says, the lordship kindly see paragraph 6.
Anyway, I'm granting you time
No,
to
no,
reply.
paragraph
But I'm not, otherwise I'm not inclined.
Well, what paragraph 16 says, below?
The maintainability of the writ petition itself is at stake.
No, definitely.
You are in wiki,
Now, the question, my lord, they are only 1.1 crores below. Say, suppose if I undertake, that I will give the 1.1 crore. Their affidavit is saying that.
Sir, so far as the
That-
entire writ petition is concerned, you are in, I mean, on a lighter note, you are on a sticky wicket. So we'll grant you sometime, we'll dispose it on 22.
Well,
Maintainability also,
oh,
he has not raised. I mean, indirectly, he's trying to point out. Yes.
that there is nothing to be decided because he has alternative remedy here. That's it. That's why this is
Ultimately, you
not-
are trying to say
Yes,
that
this is
it's
not
not
maintainable.
maintainable.
Well, this
Writ petition
petition,
is not maintainable.
that's a different thing.
So I have not heard him fully because say motion stays. Whatever he wants to submit, I have not allowed him to
22nd
complete his
Lordship,
argument
20
because what
22nd
I wanted
Lordship
to
fixed
learn, what I want to, I wanted from him, I have understood. Therefore,
Lord,
I have stopped in
that is why we are coming
midway.
for the justice, my lord.
So you file a reply if you want to file a reply.
My lord.
Fix it on next date and we'll consider.
22nd, my lord,
But you think about this
Definitely, my lord,
maintainability
definitely.
also.
On 22nd, my lord, your lordship may fix.
The issue will be mainly on maintainability.
Definitely,
right.
my lord. My lord, on 22nd, your lordship will fix. Because every month I have to pay 25 lakh. Sorry,
I
2.5
understand
lakhs. Whatever it may be.
That's the ill luck.
Uh,
That is called sheer ill luck.
And that is why I am coming for the temple of justice for getting to.
But Temple of Justice they must have a case to be interfered with.
Uh,
To provide a justice, we cannot provide injustice. Justice to all,
Justice to all,
not to
below.
only one,
And
depriving
whatever it may
others.
be, for the fault of person, innocent person will be suffering, and each and every month you have to pay 2.5 lakhs.
As Mr. P. Bora, learned. No, heard Mr. P. Bora, learned counsel, senior counsel, assisted by Mr.
HK Sharma.
SK Sharma, learned counsel for the petitioner. should I record that the maintainability
No,
of the rate principle? Huh?
My lord,
That is always understood. Anyway, we are not saying anything today. We are not passing any order. Let it be. Or should I record it, sir?
my lord, it will be, no, indication is a different thing, lord.
May the learned
But
Mr.
in the
Dinath,
affidavit also, they do not. have a-
Dinath has learned senior counsel, a senior government advocate for the respondents has filed the affidavit. Although the no notice has been issued in this matter, Mr. Mr. Bora learned senior counsel, praise for and is granted
22nd law, 23rd law.
2 weeks time, no, a week's time to
My lord.
file reply to the said affidavit filed by Mr.
Oh,
Nath,
22nd law.
as agreed to by learned counsel for the petitioner. Parties, let this matter be listed on 22nd, 01/2026 for further consideration of the matter, including the maintainability of the rate
My
petition.
lord.
It's always there, whether there is not. All right, okay. I've indicated, including the maintainability. For further consideration, including the maintainability of the writ petition. It's okay, I think it should not prejudice to you.
Definitely, my lord.
Indirectly, why they are filing the writ affidavit? To say that the writ petition is not maintainable.
My
They will
lord,
go and say, this is my.
Anyway,
Mm.
okay,
my
anyway,
lord,
we'll
also,
hear you
my
on
lord,
22nd.
Also, my lord, what they have been jamming, and now they have filed that investigation has not been over.
Sir, I don't have to tell you, you being a senior lawyer and a seasoned lawyer, don't make them more wise, more wiser.
Yes, that I know.
Don't make them more wiser.
That I know, my lord. But I am not appearing there, my lord. I am not appearing there.
No, it will be under your, the settlement, under your supervision only.
I'm obliged with that.
Lordship, my senior is on legs in court 10.
What is the matter?
We kindly have the matter at 2 p.m.
Yes.
Respondent number 4 is a library.
Huh?
Lordship, respondent number 4 is a library. Lordship, we have filed affidavit. Lordship will kindly have a look, Lordship, at page 62 of affidavit.
See, what is the title suit is in,
Lordship pending before the Dhemaji District Court, Lordship. There is a title suit as well as miss case
title suit by whom?
by respondent number 4, Lordship.
You have filed that title
Yes,
suit?
Lordship.
It's pending.
Pending, Lordship.
There's no, I mean, interlocutory order. There are no
Actually-
orders.
No orders. Actually, date was fixed yesterday, but the presiding officer was absent. Hence, another
Who is respondent number 4?
that Nolinipam Library, Lordship.
Huh?
Respondent number Nolinipam Library.
Nalanipam Putiboran.
Library, Lordship.
Putiboran is Assamese.
Assamese, Lordship.
It's a government library.
Library.
Library of what?
Library, Lordship. That in books.
Of what? By whom? Private parties.
Respondent number 4 is represented by the president and secretary.
No,
Lordship.
private parties.
Private party, Lordship.
So that you need to have a valid allotment.
Yes, Lordship. Lordship, we can see, Lordship, page 62, Lordship, of our affidavit, Lordship.
No, where is there any action has been initiated by the state? Yes, mister? Saying what?
Case 43.
Huh? Phase 40? 43. Yes.
Is pending, my lord. The executive officer, Dhemaji Municipal Board, that is page 44. The informed that eviction would not be carried out at the matter is sub judice before the Dhemaji District Court, my lord.
Achha. Otherwise, he is also not entitled. Otherwise, you are also not entitled. That's why I'm asking, is there any interim, the interlocutory order?
43, that with regard to the statements made in the para 3, the writ petition deponent admit the correctness of the same and respectfully says that SDLC held on 8 a quantum of 4/7 lesser
approve for allotment settlement of debt in
Petition.
favor of the petitioner covered by Doc number 190, number 4 block Dhemaji, and accordingly general land sale certificate issues dated Omuk Bhait book in favor of the petitioner. There has been allotment file. That is in our
Lordship, what happened? The total land, 4 katha and 7 lasses of land, which is in favor of the respondent number 4 library lordship since 1973 lordship.
But facts remain that as per the record, it has been, approved in favor of the petitioner, not in your favor.
That was
It's okay, why not on the whole land? Petitioner is not also on the whole land.
7 less.
Huh?
total land, 4
4
katha,
cutters, 7 ledgers.
lordship. But it was divided that the,
You don't use this.
what happened
You
lordship?
don't use this 4 cutters, 7 ledgers.
That is divided in 2 parts and one part has been allotted to the petitioner Christie Bhavan lordship. That is the case lordship.
Petitioner is also a private party,
Private party lordship.
private body,
Private
society.
Society lordship.
Yours is also society.
Society lordship. We are
How,
registered under the
this
society.
is what,
act.
this is what title suit is for what?
Against that eviction order as well as for declaration lordship.
That's why I'm asking, is there any,
Actually, yesterday was the date lordship, but yesterday presiding officer. the
who is your senior?
Mr. Chief Portal Lawyer.
Huh?
Mr. Chief Portal Lawyer.
G. Bodoloi.
Date may be fixed lordship.
Why? There's nothing, there's nothing. When the matter is pending before the trial court. But when there is no interim, if there's no any interlocutory order,
7 was the date. Yesterday was the date lordship. But due to absence of the officer lordship, the learned judge lordship, the matter was not taken. That is why another date may be fixed lordship.
no.
And it is clear lordship.
Have you not
Sub judice
have
lordship.
you not sought for the any interim order?
It's case for
Any
injunction.
injunction or
Lordship,
whatever? It has not been considered.
No, the
The
miscase
petitioner is also
party, the
different.
respondent there lordship. But what happened yesterday was date, but due to absence of the judicial officer lordship.
Yes, declaration for what?
Declaration for
These are all unnecessary matters.
the matter is sub judice.
Not a question of sub judice.
Or any other date may be fixed lordship, let the learned district court of Dhemaji, if any outcome of that title suit as well as miscase.
No, you cannot be allowed to hold. The land is a government land or what?
It has been government, it has been allotted, my lord, it has been approved and allotment settlement in favor of the petitioner with regard to 4 kotha and 7 lesses. The eviction by my lord, the ejectment could not be carried out only due to the pendency of the suit. No injunction, but.
Yesterday was the date lordship on 7th.
Titles.
Just have your song.
This eviction,
From the municipality board lordship. Eviction notice was issued and against that notice. as
you have
well as,
filed a
that title suit as well as miscase lordship before the.
title suit cannot be filed.
Seeking a declaration
Dec-
not to give effect.
Ah,
I think
lordship.
so, with regard to that eviction notice.
And injunction petition for
and,
miscase.
Petitioner filed this writ petition.
It is
seeking
called
an
a title
eviction-
suit. Title suit too, you cannot. I think your title suit has been dismissed, rejected.
Pending.
No, you have filed again the eviction against the eviction.
Yes.
Eviction order dated 21/6/2025.
Yes. So that matter has been pending lordship. So another date may be given lordship.
That's why I'm asking, any order passed by the,
Yesterday was the date lordship, but due to the absence of the learned judge lordship, yesterday the matter was. not-
you obtain, otherwise we'll direct them
Yes,
to
lordship.
evict you.
Lordship, another date may be given lordship.
We'll dispose of the matter. Call your senior.
Or at 2 PM lordship.
PM no, so PM nothing. কালি fix কৰি দিম।
Kindly,
No,
they
tomorrow.
also approach for another date, Lordship.
Huh?
2 PM or another date, Lordship.
Huh?
Or another date may be given, Lordship. Any date.
কেতিয়া আহিব পাৰে?
We'll take after 15 minutes. We have enough time. 15 minutes. Inform. Call your senior after 15 minutes. Hmm. You just see what is the way out. I think writ petition may not be maintainable.
Lordship.
They should approach whatever they want to do, they do there. Right?
Lordship.
Anyway, we'll dispose of the matter
Lordship.
after 15 minutes. huh?
Lordship.
Right? Inaction of the government.
না এই করা তাতে তেওঁলোকে মুখ কৰিলেও তোমালোকে কৈ এটা বেলেগ ডেট লোৱা নহয় আৰু আমি দেখো অ্যাক্সিডেন্ট আৰু সদায় তোমালোকে ধৰা ক্লাইণ্ট খুলি দিলা আকৌ মোৰ লগত এবাৰ কি কৰাই দিব লাগে ন সঁচা হয় নহয় সিহঁতে কি মানে হিয়াৰিং কৰি আছে আমি কৰা আমাৰ চিনিয়ৰ আহি কৰিব কি হাইকোৰ্টত আছে আপোনালোকে কি ইনষ্ট্ৰাকচন হয় মানে স্যার আরে স্যালারি উঠে কালি কিমান কৈছে বেলেগ কথা কিবা ইনসেন্টিভ পাই টুর করবে একটু বেলেগ কথা স্যালারি স্যালারি এটাই থাকিব চুরি করেছে চুরি করেছে ব্যাপার কিছু ঠিক করে
ये चाहिए तो ले जाता एक बार अकाउंट्स में आप बोल दीजिए ना कि भाई यहाँ ठीक करता है हाँ सॉन्ग जिसको बोलना है बोल चुका है Ultimately, mentally, like, up to date. What about this up to date?
Sorry, Lordship, I wasn't.
No, it's okay. I think Mr. Bordoloi, since the matter is pending before the trial court,
Lordship.
you approach. You are a party there,
Yes,
you are
yes, I have-
defendant.
in fact, I have
Better to
appeared-
withdraw and we'll give you a liberty.
Lordship, Lordship.
Because your only prayer is that he
Regarding
should be
the
evicted.
eviction
That
notice.
order has been put to challenge.
Lordship.
It's
In
a,
fact, your Lordship, if your Lordship kindly takes up page 40 of my read petition, that is the eviction notice. Now there, if you.
that they have brought, they have challenged it in the trial court.
Yes, but here your Lordship, if your Lordship kindly take page 40 of my read petition, and
Yes.
extra 10. Now, if may I read it, your Lordship?
Page 40.
Page 40, Lordship. Now, this is to inform you that as per the judgment and order that so and so by the Honorable District Judge Dhemaji, you are hereby directed to vacate the daily market running from the allotted land of Dhemaji District Yuva Kistri Bhavan Managing Committee within so and so.
Otherwise, the Dhemaji Municipal Board will take necessary legal action against you.
Yes.
Now, here what happened, rightly, wrongly, a settlement has been made in my favor and the land should be in my possession. However, as on date, it is in possession of the respondent number 4 and subsequently a title suit is pending. Moreover, your lordship, they are running a daily market from that particular plot of land.
Approach that, the
Yes, Your
authority, it's the district judicial, I mean, the court
Lordship,
is the, I mean, the civil court is the
Civil
appropriate
court is-
authority.
Lordship, lordship,
Since it is,
lordship.
maybe he's entitled, I mean, he has the case or not, that is different
That
issue,
will be
but
decided by the learned court.
yes, so you approach them.
Lordship,
We'll give you a liberty.
lordship,
You better to withdraw.
lordship.
Yes. Heard Mr. G. Bordoloi. G. Bordoloi, Land Council for the petitioners. Petitioners. Fairly submits that he may be allowed to withdraw this writ petition with the liberty to approach the civil court where the issue of title in respect of the subject land and the eviction order passed by the
Dhemaji
authority,
Municipal Board.
Dhemaji Municipal Board is pending. Mr. So and so, all of them are present,
For SK Sarkar.
the expert, are present, Miss Seven. You,
Number 4, SK
I use are present, considering that the matter and then the issue of title in respect of the subject land and the consequential, subject land. What I said, considering that the filed by the respondent number 4, namely so and so, you will just give the name. And the eviction order is pending before the civil court, Civil judge. Senior Division Dhemaji. The prayer for withdrawal of the writ petition is accepted. Accordingly, writ petition stands closed on
Yes,
Civil court to dispose that.
on
it
withdrawal
will be otherwise, because
with the
otherwise,
liberty
yes,
to the petitioners to approach the civil court, a civil judge within bracket, Senior Division Dhemaji, for necessary orders.
Lordship, we are party when we have.
For
final
necessary,
decision.
for approach, we'll just say approach.
Lordship. Lordship, a time frame if you lordship.
No, you approach. That will be
civil
within
matter,
the jurisdiction of that
Time
court.
frame, my lord, otherwise he said.
We cannot assert,
Comment then otherwise, lordship.
we cannot assert.
Highly
You
obliged.
just approach.